Welcome everybody to this timely webinar topic. Even though I think I looked shortly before the presentation and over 73 million people have already voted, this is still a timely topic because, as I understand it, we're expecting record voter turnout for the election in less than a week, and so there's still a lot of people who may vote, which is one piece of this presentation called Campaigning and the Workplace. I've got with me my esteemed and much wiser colleague, Mike Brittingham, who is going to talk about some benefits-related issues after we do some campaign and political speech-type issues to start. My name is Grant Close. I am a labor and employment attorney with Nexon Pruitt Law Firm located in our Greenville office. I hope you're all very familiar with us and expect that many of you are, but in case you're not, Nexon Pruitt is a full-service business law firm located primarily in North and South Carolina with several offices across each state. And Mike and I practice in our employment and labor law practice group, where we have over 25 attorneys in both of those states practicing pretty much exclusively in the areas of labor law, employment law, and employee benefits, which is Mike's area. So we're glad to be with you today, and we appreciate you joining us for this presentation. To get started, there Mike and I should have already done that one, but to get started, we'll outline our time together, which centers around election season, which I think has two meanings for the purpose of today's presentation: political elections and the election of benefits through open enrollment, which Mike will talk about again here in a little bit. So whether that was intended or not, that's a clever slide for us to begin with. Our outline is that we're going to start by talking about voting leave laws, always something to be aware of, particularly if you are an employer located in multiple states, and then talk about campaigning, which has a couple different meanings in the workplace, whether that be political campaigning or just expression of political beliefs, and how to handle that through awareness of laws that are implicated with political expression in the workplace, and also how you can control those types of things through policies and planning. Then Mike will jump into his tips for open enrollment this year and some e-disclosure guidance from the Department of Labor when you're dealing with electronic retirement plans. So to start, voting leave, something that we may not think about all that much, particularly if you're located in North and South Carolina, because the most important point to note on this slide is that North and South Carolina do not have laws regarding or requiring voting leave from work in order to vote. But this slide tells you which states do have those laws. And so take a minute to look at it. Even though North and South Carolina don't have voting leave laws, it's still important to think about how people's time away from work to vote, assuming they take that time or are allowed to take that time, plays into your other policies and procedures. If I've talked to any of you about an employment-related issue before, you'll know that one of the first questions I ask after you tell me about the situation at hand is, what do your policies say? And it's the same thing here, that we always want to consider, even though there's not a law in play in North and South Carolina for voting leave, that you may have policies implicated by employees leaving to vote. For example, you may have your general absence or attendance policies that tell you what notice employees have to give in order to, for example, come in late if they're voting, or leaving early to vote, or voting on a lunch break, things like that. So consider whether you need to get a quick refresher of your own policies that may come into play as people are voting, particularly those who may have already voted, which, as I understand it, in lots and lots of places is taking several hours to do. So if they're doing that during a workday, then you may have some policies implicated, and you may have some potential disciplinary issues. For those states that do have laws, those laws have various requirements. Some of them require paid time to go vote, and others require unpaid time to go vote. Some have notice requirements that the employee has to give notice of the need for the leave. Some limit the amount of time an employee can take. Some talk about whether an employer can specify when the leave can be taken to vote. And then at least one, I believe Maryland, even says that the employer can require proof that the employee voted as a part of that law. So many things come into play and to consider if you have employees in states outside of North and South Carolina. So shifting from voting leave to politics, essentially, in the workplace. And this slide is intended to convey that political discussion and impact of that discussion appears to be on the rise in the workplace, whereas talking politics may have once been taboo in public. It's not anymore, or less so now, and so it's more of an issue that we're seeing employers deal with and sometimes struggle with. That there are political, well, generally on the right-hand graph, there is simply more political discussion happening in the workplace. That is on the rise. And then what follows is the graph on the left, which essentially says that because there's more discussion, there's more disagreement. And as we all know, disagreement in the workplace is often what creates issues for you all to deal with, and sometimes for you all to call us to help deal with. And those things are something we want to be careful of. Another point, or another statistic that's not on the graph, is that 12% of people, this is a SHRM, Society for Human Resources Management statistic, and they have another one that says that 12% of people felt that there was political affiliation bias, that they were subjected to essentially adverse treatment, or disparate treatment, I should say, based on political affiliation in the workplace. So the issues, you can see sort of the ingredients for there being issues. So to expand on that a little bit, why would you want to limit or consider limiting political speech and conduct and discourse in the workplace? And the fact that some people feel that they have been they've had disagreements over politics, and the fact that people feel they have been treated differently because of bias in politics should say it all. But those are distractions that are not going to benefit, most likely, your company and your workplace, your culture, or your productivity. Disagreements among coworkers can easily lead to disciplinary actions, and then possibly claims of violation of employment laws like discrimination and harassment laws. They can also lead to situations where customers are offended or feel mistreated, which can lead to lost revenue, among many other things. So there's a lot of impact on you, the company, that comes from political speech and discourse in the workplace. So then what can we do about it? Can we do anything about it? And the answer is yes, there are things you can do about it. Certainly, there are both proactive things you can do, policy and procedure-wise, as well as many considerations when you're dealing with a situation like this to try to do it, in the most, of course, lawful but effective way possible. So some of the things we always want to consider and that will come into play in future slides in this presentation are whether you are a public or a private employer, of course, whether the employee is at will or has an employment agreement, although it's unlikely that an employment agreement would speak directly to political speech or political conduct. These last two, though, are the big ones. Where the employer is located, because state laws come into play, sometimes significantly into play, and then whether the speech is related to working conditions. So taking that last point further, the National Labor Relations Act, or NLRA, has a lot to say in this area. And you may all be thinking to yourselves, what is the NLRA? Or I haven't heard about the NLRA in a very long time, and that's understandable if you are, particularly if you're in North and South Carolina, where we have unionized employee rates around 2%. We don't always think about the National Labor Relations Act, which is the law that gives employees the right to unionize. In that first bullet point, you can see the right to unionize, something that we tend to be somewhat familiar with, but also the right to join together to advance employee interests. And this is the big one, to engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. The piece of those rights that we want to pull out of there for this discussion are the engage in concerted activities for the purpose of mutual aid or protection. And that means employees working together in concert with one another for their own mutual aid or protection, to advance their own interests or protect themselves. We call that, sort of in the business, protected concerted activity. So if employees are engaged in concerted activity in concert, then it is generally protected under Section 7 of the National Labor Relations Act. And that protection comes when the National Labor Relations Act says that an employer cannot interfere with employees engaging in protected concerted activity for their mutual aid or protection. So they are protected from interference with working together to help themselves, in short. And we're going to look at some ways that political speech and discourse and political opinion and activity, any conduct related to politics, can come into play with protected concerted activity. All right, so to help illustrate how this can come up, here's a hypothetical. An employee distributes flyers at work in support of a political candidate. The employee's flyers encourage coworkers to vote for the candidate because this candidate will raise the minimum wage for everyone, thereby increasing the employee's pay. Is this protected speech under the National Labor Relations Act? Is this protected concerted activity because employees are distributing and reading flyers to encourage workers to vote for a candidate, which is the political part in order to raise the minimum wage, meaning for their own protection and benefit. The short answer is that this certainly could be protected concerted activity. And that would be a situation that you want to handle very carefully and think through if you were going to try to prevent or correct any misconduct related to those employees distributing those flyers. And let me back up a minute and say, no, I'm sorry, that'll be coming up. So an actual case, this is a U.S. Supreme Court case that can help sort of further illustrate what we're talking about, or a real-world situation where politics intersect with protected concerted activity, is this EDisclosure versus the National Labor Relations Board. You may not know, because hopefully you've never had to deal with a Section 7 or a protected concerted activity case, but the National Labor Relations Board operates differently than a lot of other agencies, a lot of other agencies, because they have their own adjudicatory body, meaning they make decisions on their own that then get appealed to courts. And so in this case, the National Labor Relations Board made a decision in favor of the employees, essentially that they had engaged in protected concerted activity, and that the employer had unlawfully interfered with that activity, and it got appealed up eventually to the Supreme Court of the United States. Backing up one second. So in this case, it involved employees who were distributing labor union information, a newsletter. They were doing it in non-working areas and during non-work time, and those are important points. In other words, they were doing it in a way that is protected by the National Labor Relations Act. And I'm going to talk a little more about solicitation and distribution policies and how to do those correctly in a few minutes. But essentially, they were following or acting within their rights under the NLRA to distribute this material. And the material said a couple of things. It advocated for supporting the union, which is maybe not surprising if you've ever dealt with labor unions. It advocated for opposing a law going into effect, a law that was on the ballot for right to work law in this state. And as a very quick aside, just a reminder to all of you, since this gets mixed up sometimes, right to work laws they often get mixed up with at-will employment laws. Right to work laws say that you have a right to work without joining a labor union. You can't be forced to join a labor union in a workplace, even if that workplace is unionized. That's a right to work law. So it gives employees freedom to choose whether to be represented by a labor union, or to have to join, I should say, join and pay dues to a labor union. At-will employment laws are the ones that say that an employee can be terminated for any reason or no reason whatsoever, as long as it's not an unlawful reason, with or without notice. So that's at-will employment versus right to work. This group was advocating advocating to oppose the right to work law, meaning they don't want a law that says you don't have to join the union to go into effect. So that's sort of a political component. They were also critical of a federal veto of a minimum wage law, an increase to minimum wage. So another possibly political purpose to this communication. They were criticizing a vote that disallowed an increase to the minimum wage. And then they generally advocated for voting for candidates who would support their causes. And the employer in this case, after this information had been distributed in their workplace said that they did not want and were not going to allow this information to be distributed. And they said that if it's political in nature, then it's not actually intended to mutually benefit and protect the employees. In other words, it shouldn't be protected by the National Labor Relations Act. And the issue went up to the Supreme Court of the United States, who said that mutual aid and protection, meaning employees working together to protect themselves, is not limited just to activities that are directly related to their employer, their employment relationship with their employer, meaning the wages they earn from paycheck to paycheck or the breaks they get to take on a daily basis. It's not limited just to that. It can extend to the type of things that these materials we're talking about, being critical of the government and advocating for laws that would benefit them. So even though those might be political in nature, those were still protected by the National Labor Relations Act. So all this is to say that there is often an intersection of the National Labor Relations Act and its protection of employees working together to benefit themselves and political activity or speech. So be very careful of that, even and that would apply to essentially every private employer. Now, you can also get the intersection of political speech with discrimination and harassment and other laws. And so what to do when that happens? I've been seeing this, to be perfectly honest, a lot more, and I don't say that just for the sake of this presentation. I've been getting more and more calls, particularly about employees making often public Facebook and other social media posts that invoke race or religion in these, particularly political and maybe difficult times with lots of social and racial issues that our country has been facing. There's a lot of strong opinion, and people, as we all know, tend to take to social media to express those opinions. And so employers are having to deal with somebody in the workplace seeing those opinions on social media, potentially being offended by them or just wanting the employer to be aware of them, and then having to decide what they're going to do about it. Well, if it's something that involves race or religion, for example, or national origin, or any other protected category, then you need to be careful in how you deal with that situation. What we try to do, just because speech might be characterized as political or involve a political candidate or have some other tie to political speech, that doesn't mean that the person is exempt from following other employer policies and procedures. And so what you need to look for is whether the conduct violates any other policies and procedures, like your discrimination and harassment policy or your social media policy, your code of conduct, your code of ethics, those kinds of things, and determine if you think it is a situation that needs to be addressed by you, the employer, in the first place. Determine, how you can address it using policies and procedures that do not implicate directly the political nature of the speech. So in sort of short, try to avoid the political piece of the speech and focus on anything else it may do to disrupt or harm your workplace through other policies and procedures that you have in place. Here is a hypothetical in this situation, but it's a little generic, and I think I've explained it enough. I told you I've seen a lot of this, and I was thinking through some of the real-world examples that I might share with you all, but they were, to be perfectly honest, they were all just too likely to offend someone, and so I'm deciding not to give you a real-world example in this situation. I think you'll see it, or you'll know it when you see it if you run across one of these. A big thing to think about in the event you are a public employer that the First Amendment puts restrictions on public sector employers from limiting free speech under the First Amendment. And this is can be a huge topic. But the takeaway for today is that if you are a private employer, you can debate that First Amendment is important to you as a citizen or just person, but you don't have to be concerned with violating the First Amendment for the most part, in workplace issues. So you can have policies that say, that you can't say something discriminatory to another person, and that does not violate someone's right to free speech under the First Amendment in the private employer context. In the public employer context, there's another analysis that you would need to do, but that is probably outside of this presentation today. All right, I'm going to start to speed up a little bit because I don't want to encroach on Mike's time, but this is an important slide because this slide talks about a South Carolina statute that protects political speech in the workplace and outside the workplace. And what this law does is, in the employment context, it says that you can't terminate someone's employment for exercising political speech rights or other rights to political opinions that are guaranteed by the U.S. Constitution or the South Carolina Constitution. And that can get, when you start analyzing each part of that law, it can get a little complicated. But what you need to know for flagging this issue so that you can look closely at it is that you cannot simply terminate someone's employment for expressing a political belief or opinion, for being affiliated with a particular party, for donating or refusing to donate to a political party or a political action committee, all those types of things that surround politics, you cannot terminate someone's employment for. Interestingly, you also can't, according to this law, intimidate people for any of those reasons, and you can't eject them from property for any of those reasons, and just in case any of those things might apply to you. Now, a very interesting thing about this law that always grabs my attention is that this is a criminal statute. This is not a civil statute. And so this, if you are found to have violated this statute, you're guilty of a misdemeanor, and the penalty can be up to $1,000 fine, 2 years in prison, or both. And so there are a lot of teeth to this law, and I hope that has piqued everyone's attention. It's not something you want to take lightly. That's why when you get a situation where you have a Facebook post that maybe makes a racial comment tied to a political candidate or a political party affiliation, and you think that that violates one of your policies and is something you need to address, and you probably do need to address it in a lot of situations, then you need to do it very carefully and very intentionally, and if you want, and we would advise with the help of with a lawyer like us, of course. So just remember that this is also this statute can also be used for a civil lawsuit, because the courts have said that if you violate this law in the employment context, then you have violated a public policy of the state of South Carolina, and therefore there's a cause of action. You can be sued for something called wrongful discharge in violation of public policy, and that's a civil lawsuit that carries the potential for punitive damages for terminating somebody's employment or taking adverse action against them, essentially because they were protected under or followed a law. So how far does that go? An interesting case that was not too long ago, and that I have to say with a quick plug was defended by one of our own attorneys, William Floyd, in our Columbia office, was against John Deere, where the company prohibited an employee from displaying a Confederate flag on his toolbox in the workplace. And the question was, is that protected political speech, the Confederate flag, and therefore, did the company violate the law that we just discussed in South Carolina? And the court determined that that was not political speech, but to be perfectly honest, the opinion did not give us a whole lot of guidance on how to analyze these issues. What it said very generally was that protected political speech in South Carolina is more related to things that involve the executive, legislative branches of the government, the administration of the government itself, party affiliation, and right to vote and right to contribute to parties and all of those kinds of things. Although the Confederate flag has a lot of different meanings, essentially, and it might be somewhat related to political issues or speech, it wasn't directly related, and therefore it wasn't protected under the law that we just discussed. So interesting case to try to find that line, which can be very hard to find between protected political speech and maybe social speech of different kinds. Another sort of interesting article and situation that occurred in a workplace was in 2018, I believe, at a Cheesecake Factory restaurant in Miami, where a patron of the restaurant, a customer of the restaurant, with his family, or with a group of people he knew, was mistreated by employees of the Cheesecake Factory for wearing a Make America Great Again hat in the restaurant. And so the allegations were that the employees were making comments, that they were pounding their fists, making fists around the customer and pounding their fists, and were kind of physically confrontational with the customer, things like that. And the Cheesecake Factory terminated the employment of those employees essentially because they had violated a policy, but I think they would say even a central tenet of their restaurant, which is that all customers should feel welcome. And they issued a press release to that effect and took employment action against the employees. To my knowledge, there was not legal fallout from those employees being terminated, but the point is, how do you address conduct that could be described as political, employees taking a stand against a political slogan tied to a political candidate, and how do you operate your workplace the way you want to and feel like you need to despite that conduct? And here, the company relied on, an unrelated company policy that I'm sure they argued was very important to them, a central tenet to their business, that you have to treat customers with respect, sort of no matter what, and took that action against the employees based on that. And that goes to what I mentioned earlier, which is if you're going to have to take an adverse employment action because of conduct that might be considered political, do your best to tie that action or to distance that action from the political nature of the conduct. Or if there are different types of conduct, some political and some more, for example, discriminatory, then focus on the stuff that's not political and try to distance the whole decision from stuff that is political. And I'm sure you all are adept at documenting and those decisions, which is important in these cases so that you can make it as clear as possible. And so we can defend you as well as possible if you get a challenge about making a political decision or violating a political speech law, that decision was not at all based on the political speech. It was for these other things. I do want to quickly mention that North Carolina has a statute related to this topic, and that it also creates a misdemeanor, so a criminal violation, if an employer discharges or threatens to discharge an employee because of their voting decision. I don't practice in North Carolina, but I would guess if I went and looked that this law has probably not been violated or challenged a whole lot of times. I would say it isn't. It creates kind of an interesting example, which is that you, the employer, in almost any case I could think of, would not want to and should not know how a employee votes, the way an employee votes. So certainly don't go out of your way to find out how an employee votes. I can almost guarantee you, if you were to ask an employee how he or she voted, the very next week that person would be a no-call, no-show for 4 days in a row, and you would want to take employment action based on that conduct, and you'd be in a little bit of a pickle because that employee is of course going to come back and say that your decision was based on their vote and not their no-call, no-show status. So just be very careful with that. I want to quickly touch on some policy really reminders and what you can do policy-wise. We've talked about policy-wise, I should finish that sentence, to protect your company against accusations of unlawful political bias or interference. It's worth reminding, and I always have to make a note of this because it's for some reason it's always been confusing to me. But going back to the National Labor Relations Act for a minute, and that case that we discussed where I said that the employees who were distributing union materials outside of the work area and outside of work time, how they were allowed to do that, that's a lawful activity. The National Labor Relations Act allows employers, of course, to have no solicitation, no distribution policies, but you have to be very specific in how they're worded because there are limits to what you can prohibit. And so I wanted to just give you those limits quickly as a reminder. Non-employees, you can prohibit non-employees from soliciting or distributing on company property at any time. You never have to allow non-employees to solicit or distribute. Employees can be prohibited from soliciting during work time, okay, during work time. So they can solicit outside of work time. Employees can be prohibited from distributing literature or anything else during work time or in any work area at any time. So they can never distribute in a work area, and they cannot distribute during work time. In the example we looked at, they were distributing outside of work time and outside of a work area, and that's why it was okay in that case. But those are limits to always remember. If you haven't looked at your no distribution, no solicitation policy in a while, if you don't have one, certainly would recommend you having one and trying to consistently enforce it, which can be difficult because you want to allow solicitation for nonprofits, selling Girl Scout cookies, selling Boy Scout popcorn, all those kinds of things. And I think those things can be carved out of a non-solicitation, non-distribution policy. But you need to be clear about, what can and can't be done and making those distinctions in the policy so that so that someone doesn't come forward and say, well, as soon as I tried to advocate for a political candidate by handing out buttons, I wasn't allowed to do it, and now the policy is being enforced unequally. Similar concept for dress codes. You can essentially create dress codes as you need to. It's something you need to think about on the front end, have good reasons for, and and be intentional about, so that you can actually apply them consistently and accomplish what you want. I do not want to cut into Mike's time. The last two slides were just some recent real-world examples of dress code issues involving social and political speech. There's one about Black Lives Matter and Starbucks. If you were to just Google those two terms, it would come right up. And then some big name companies creating policies that limit political conversations and opinions in the workplace in various ways. So that's being done more lately, I think, as these political and social issues have been ramping up in the last 18 months, 2 years or so. So things you can look at if interested. I've enjoyed our time. If you have any questions that you want to type up while Mike is presenting, I'll try to take a look at those. Mike, I hope I've left you enough time.
Thanks, Grant. No, I think I have plenty of time, and I enjoyed your part on the politics. I always learn a little something. We're going to change focus completely and go over to my practice area, which I generally like to describe as the intersection of employment law, tax law, and some business law. So we're going to talk about, if I can start through these slides, we're going to talk about open enrollment issues generally, and with different specific topics, including things to think about during open enrollment. We'll talk a little bit about COVID and COBRA, some guidance we have there about some suspension of election periods and some COBRA litigation and some thoughts about that. And then lastly, we'll talk about the DOL and its issuance this summer of some new EDisclosure regulations where employers who are plan sponsors of retirement plans can provide plan documents and other plan information, including statements and investment fee expense. Any kind of reporting that's required as a plan sponsor can be done electronically. It could save you a lot on hard copy print cost and just time of stuffing envelopes, et cetera, et cetera. So that's the main topics for today. So let's get started in detail. The first slide here is just, I think it's always good to have a level of awareness of the types of things that you have to provide annual notices of. And the first thing you see on the list is summary of material modifications, and that's just a fancy term of art, so to speak, for tell everybody if you've amended the plan this year. So if you've got an ERISA governed plan and you've made changes, you need to issue a summary of material modification. And of course, if you want to just reissue an amended and restated summary plan description, you can do that in lieu of this summary of material modification. It's, again, just a way of communicating plan changes. And then every year, we're all familiar with 5500 reporting, where for every employee benefit plan, unless you're certain thresholds, we have to report on a 5500, and that 5500 has to be reduced down to what's called a summary annual report, and that information be distributed to participants. For group medical plans, there are summary of benefits and coverage requirements. It's an outline or summary document to list the main coverage eligibility terms and coverage terms for the medical plan. That requirement was ushered in by healthcare reform back about 10 years ago or so. Then the next three on the list are just, they've been around for a while now, and they're annual notice requirements. And what we usually see is your benefits brokers or your third-party administrators are pretty good about putting this together, but if they're not, there are sources to get model language for the CHIPRA notice, which has to do with child health care and Medicaid. Then there's the Newborns Act, and then lastly, the Women's Health Cancer Rights Act, the WICRA notice. Those three notices have to be given every year, and it's just good to include it in your open enrollment material. The last three items have to do with retirement plans and reporting there. The law, just in very high-level summary, requires that you give benefit statements on your retirement plans at least once a year. For most employers with 401k plans, that statement reporting, if it's not instantaneous, it's at least once a quarter, and generally, or once a month even, those get out. But if you have a defined benefit plan, of course, you would still need to report that out once a year. The qualified default investment alternative notice is just to make people aware that if they don't make an election in a defined contribution plan with participant-directed investments, if you don't make an election as a participant, where you tell them where the funds are going to be invested, the qualified default. And lastly, every year, tax-qualified retirement plan with participant-directed investments has to make people aware of investment fee and other plan costs through required disclosures. So those are the high-level annual requirements or other reporting requirements. One thing, if you're taking some notes, if you want a more detailed summary of these types of notices, and a very good resource, if you simply went to Google, typed in DOL and Reporting and Disclosure Guide, it's about a 6-page Adobe file that's very, very good. That it summarizes the reporting requirement, what's included, references, and I think it actually has some direct links to model language. It's a very good resource that Uncle Sam provides, and I would direct you to that resource. Very good resource. The next thing I always like to mention when I'm talking about open enrollment, it's just a really good time to reconcile perhaps your payroll to your plan census for all your employee benefit plans. I think it's very important that we make sure that we identify from payroll or some other source, but payroll is probably the best one, who are employees and then who's eligible, and make sure that we have everybody that's eligible in the plan. And then if we have our list too long in the plan and people that are eligible are still enrolled, we need to get them off the rolls, because one of the things we're trying to do is prevent having a situation where we have someone that's covered but's not eligible. And then it seems like probably 3 to 5 times a year I'll work with a client who has missed this issue. You'll have someone who's gone away on a leave of absence, usually for some type of medical event, whether it's, just say a heart issue or a cancer treatment issue. And the old adage of no good deed goes unpunished. Someone's out, they go beyond their FMLA leave. Someone forgets to look at how long someone's eligible to stay in a plan, whether it's a life insurance plan or a medical plan or any other type of welfare plan. And sometimes these folks get beyond when they're eligible, and we extend coverage beyond that eligibility period. And what then happens if someone has an event that's covered, and the insurer asks for information about their employment history and their hours worked, and all of a sudden we end up in a three-way dispute between whether someone should have been in the plan, whether their benefits due, or if their benefits due, who's going to pay them. So it's very important that periodically, and open enrollment's a grand time to do it, is that we reconcile our census back to our payroll. I've even seen employers on a monthly basis have a systemic electronic run through data off of payroll to identify people who are on extended leaves or not working enough to remain eligible, to be diligent about making that full-time, part-time distinction and keeping eligible people in and knocking people out who aren't eligible. It's a very important task, and it's worthy to mention that here. You'll see a bullet point there, actively at work requirements. Most welfare plans, welfare benefit plans like life insurance plans or disability plans require that someone be actively at work to be eligible. And when we had the onset of COVID back in the spring, we had a lot of people on layoff and furlough, and a lot of these group insurers were very, very good about communicating with their clients, their plan sponsors, and saying, hey, look, we're going to extend the actively at work requirements, or we're going to waive those for a while. But they did that with some writing or written publications on portals and their websites for plan sponsors. You probably need to pull that out, take a look at what those communiques said, and make sure that what you're doing to keep people covered or to terminate coverage is consistent with what your carrier issued as to what they would do to extend coverage or not extend coverage. And that all comes back to the reference that I made all along to risk of noncompliance. The risk is that we make a promise through offering or continuing benefit coverage to someone who's not eligible. Then an event occurs that triggers a benefit, and then we're in a fight between the carrier and us as to who's going to pay or how we're going to deny coverage. And that's a tricky situation to be in. It's just better to try to avoid that through diligence that we just discussed. All right. Another open enrollment step I think is a good time this year is just to remind our people, our employees, that beneficiary designations, I like to think of beneficiary designations very similar. Of course, I'm going to show my age. It's similar to writing a check. I don't know many people write checks anymore, but when we write down who our beneficiaries are, those are valuable actions taken. Declarations as to who gets proceeds from a life insurance plan or who gets the proceeds or plan balances for retirement plans. And this time of year is a good time to remind everyone. Changes happen. People get older. Beneficiaries pass away. Marriages dissolve. And so beneficiaries or marriages happen. And so beneficiaries need to be looked at and changed by our participants. And it's just a good HR thing to do to help people along. Now, on the risk mitigation side, it seems like it runs in twos every other year. This is an off year for me, but it usually comes up where there's ambiguity in beneficiary designations. And where it's hard to tell who's the beneficiary, or perhaps we have a retirement plan beneficiary form designating someone other than a spouse, and there's no consent to the non-spouse beneficiary. And what then happens is we have competing claims for benefits. And what I like to preach here is let's don't pay that twice. That's where you're at risk. And so if we know that there's some ambiguity or there are competing claims to the same dollars that we know that our plan or our plan insurer is going to owe because of an event, but we have person A and person B both saying, hey, I was the beneficiary for this reason or this ambiguity or under these circumstances, we acknowledge that our plan owes the benefit to the proper beneficiary. It's just that under the circumstances, we can't tell with certainty who the beneficiary is. The cheapest alternative for you folks who are fighting over the money is to come to an agreement between yourself, and we can do a three-way release agreement and button it up, and we're done. Oftentimes that doesn't work because, especially in a death situation, obviously the family's feelings can be raw, et cetera, or if there's had been a prior divorce and it's a new spouse and you got a former spouse, current spouse fighting over the same money, there's usually not a lot of getting along. And so How do we resolve it then? We do in federal court what's called an interpleader. It's a more cost-effective way. We just go to the court and say, our plan owes us money. These people are claiming it contrary to one another. Court, you decide and tell us who to pay, and that's the cheapest way to do it. So don't pay it twice. Don't make the decision, pay one party when you know someone else is claiming it. Employee benefits, COVID and COBRA. This is something I think to be aware of. This summer, DOL and IRS, in the wake of COVID, issued joint guidance that deferred deadlines for many things, including COBRA, extended deadlines and claims as well. And it's basically suspension of all deadlines for 60 days until the national emergency is declared over. And so we're in the middle of just indefinite suspension. So what happens then for COBRA? People who've gotten COBRA notices, they are in a COBRA election period. They don't have to make their COBRA election, nor do they have to pay the premium. Now, if they don't pay the premium or make the election, we don't have to pay the claims until they make a valid election and pay the premium. So in that circumstance, it just adds for a little more administration. Most of you guys have third-party administrators that are handling this. I would say you rely on them, but just remember, for all employee benefit plans, the employer or the plan sponsor is responsible for proper administration. So even if the third party is frontline doing it, we can still have liability outstanding for those types of things. COBRA and litigation. There's been some litigation primarily in Florida, but it's been moving around to some other states. It's generally been targeted to larger employers, and the gist of the claims are being made in like class action or group claims, and they're nitpicking the COBRA notices. And what I would recommend is that to the extent you're doing this in-house, that you use the model notices that you can find on the internet that are published by DOL, and then fill them in accurately. What these plaintiffs' attorneys are doing are trying to group together claims and get $100 a day penalty for bad notices, and then also any types of claims that people incurred that perhaps they didn't make a COBRA election when they should have. I see I'm at 3 o'clock, and I haven't gone over the new EDisclosure regulations. What I will tell you about these disclosure regulations is they're the third set of regulations that help employers that want to administer plan responsibilities electronically and add some efficiencies to the process. The discussion here in this outline, which we can send you a copy of this. If you want to shoot an email to me, I'll make sure you get it. You could go through and follow this outline. The gist of complying with the EDisclosure regulations is you give a one-time initial notice to folks that complies with the requirements for that notice. It's a written notice. People can opt out. But if they're in, then as we have disclosures, we give notice that it's the disclosure or the document's now available on a compliant website. And so people know to go log on and get to that. That notice has to have a direct link to that document that we're distributing. And then lastly, the website where those documents are have to be designed in a way where people can search those documents, they can download the documents, tell them about how they can get hard copies, etc. It's pretty good guidance. I went over by 1 minute. I did not get to all the slides, but this first slide sort of outlines the three ways or the three elements to a compliant e-disclosure set of rules. If you'll pop me an email, I'll see that you get a copy of this PowerPoint. That's it. We appreciate you joining us today. we value our relationship. And if you have a question about the political side of things, call Grant. If you want to be bored about a benefits issue, call me. And thanks so much. We appreciate it.